Hello everyone, welcome back to my YouTube channel, and in this video I'm going to share with you the power and functions of the Supreme Court of the United States of America. Now let's get started with the introduction. The Supreme Court of the United States is the highest court in the federal judiciary of the United States of America. Federal judiciary means the central judiciary of the US. It was established by the Congress in March 4, 1789 under the mandatory provisions of the Constitution. Congress means the US Parliament, which consists of two houses, the Senate and the House of Representatives. Its location is in Washington, D.C. Washington, D.C. is the capital city of the United States at present. However, the Constitution is silent regarding the strength of the court. Strength of the court means that the composition of the court, how many judges the court should consist. So the Constitution of the US does not mention about the composition of the court. Initially, it consisted of one Chief Justice and 6 associate judges. Initially means from the beginning, and associate judges means the assistant judges. At present, the Supreme Court has a Chief Justice and 9 associate judges since 1869. They are appointed by the President with the advice and consent of the Senate. The judges or justice hold office during good behavior. They have life tenure, and so they can serve until they die, resign, retire, or impeach and remove. Not like in India. In India, the judges of the Supreme Court hold office till the age of 65 years only, and in the High Court till the age of 62 years. So these are the pictures of the US Supreme Court. You can see the whole white buildings, and you can also see the courtroom of US Supreme Court, the staircase, and also the lawyers and the clients who step down the front steps after arguments at the US Supreme Court. Now let's come to the power and functions and role of the US Supreme Court. These are also called as the jurisdiction of the Supreme Court. Jurisdiction means the authority of the court. The jurisdiction of the federal judiciary or the Supreme Court has been defined in Section 2, Article 3 of the US Constitution. The following are the jurisdiction of the US Supreme Court. The first power of the Supreme Court is original jurisdiction. Original jurisdiction means that the Supreme Court have the power to try, to settle, and to solve the original case. Original case means the case which come first and directly to the Supreme Court, which was not been tried, which was not been transferred from the lower court, from the district court, or from the state court, and from the circuit court. Originate means the case which come first to the Supreme Court, or which begins from the Supreme Court. These cases involving the case of ministers, the case of ambassadors, and consuls. Consul means the representative of the US government who represent the US in another country. The function of the consul is registration of birth, issue visa for foreign citizens who visit, study, and work in United States, renewing passport, replacing lost or stolen passport. The office of the consul is known as the consulate, and at present in India we have 5 consulate offices that provide citizens and passport to the Indian citizen. The second cases which was directly tried by the Supreme Court is cases in which the federal government is a party. Federal government means the central government of the United States. The third cases is cases involving the dispute between 2 or more states. Dispute means the conflict, clash, or fighting between 2 or more states in the United States. The fourth cases is cases between citizens of different states, cases involving a state and a citizen of another state, cases involving the USA and a foreign state. In fact, very few cases come before the Supreme Court under its original jurisdiction. The second power of the Supreme Court is appellate jurisdiction. Appellate jurisdiction means that the Supreme Court have the power to listen, to hear the cases, to hear the requests of the lower court, small court inferior court or subordinate courts. The appellate jurisdiction of the Supreme Court extends to all cases which falling under the federal judiciary. It can hear appeals from all the lower courts or trial courts, that is from the 94 district courts and from the 13 circuit courts, related to the cases involving interpretation of the Constitution. Interpretation means explanation, definition of the Constitution or clarification of the Constitution, civil case and criminal case. The Supreme Court has three options to deal with the appeals. It can decide that the judge was wrong and change the judgment. It can decide that the judge was wrong and send the case back for the judge to change, or it can agree with or affirm the judgment of the lower court. If the Supreme Court finds no defects in the appeals of the lower court, it affirms the judgment. If the appellate court or the Supreme Court find defects or no proper record of evidence, witness, and proof in the decision of the lower court, it may modify the decision or send back the case to the lower court for further proceeding to solve the defect. Since 1914, the Supreme Court has been given discretionary powers to review the decision of the state court. Discretionary power means that the Supreme Court have the power to use it according to its own wills, according to its own choice. After the judicial review, the Supreme Court can declare invalid for some state laws, treaty which allege to be in violations of the federal constitution. Judicial review means the power of the Supreme Court to revise, to review, to recheck and to re-examine the law which was made by the US Senate or the House of Representatives, or it can review the appeal or the decisions of the lower courts. And if the Supreme Court finds that this appeal, this law are against the Constitution or violate the Constitution, then the Supreme Court can declare them invalid and it can kill them or strike them and cancel them. It can also declare them as not true and not correct and not a good law. The third power and functions of the Supreme Court is interpreter of the Constitution. Interpreter means the one who explains the Constitution. So the Supreme Court is the final interpreter of the Constitution. The Supreme Court is the final and the last court to explain and to clarify the Constitution. Its interpretation, its description of the constitutional provisions are finals. Constitutional provisions means all those provisions in the form of articles which are mentioned in the US Constitution. During their interpretations, the judges not only interpret the law but also the spirit of the law. As the final interpreter of the Constitution, the Supreme Court possesses the power to strike down any portion of law from statute book if it is in conflict with the Constitution. It is thus the final court to judge the constitutionality of any law or executive order. The fourth power and functions of the Supreme Court is guardian of the Constitution. Guardian means the protector or the caretaker, the one who look after the Constitution, who take care of the Constitution and who protect the Constitution. The Supreme Court acts as the protector and guardian of the Constitution. It has the power to declare any law or an executive actions as ultra vires, null and void if it is unreasonable, unjust or immoral or illegal which violated the Constitution. Ultra vires means beyond the law or beyond the provisions of the Constitutions. Null and void means not true and not correct, and it should be cancelled. So any law issued by the President, issued by the members of the Senate or member of the House of Representatives, if these laws are beyond the Constitution or if these laws are not true and not correct, all these laws should be cancelled, should be struck down by the US Supreme Court if they are violated the Constitution. The Constitution is the supreme law of the land and the Supreme Court has the responsibility to preserve and defend the supremacy of the Constitution against any violations which the executive and legislature may try to commit. Supremacy of the Constitution means the supreme power of the Constitution, the highest power, the strongest power, and the greatest power of the Constitution, beyond which no power exists. Executive means the ministers who implement the law, policies, and program of the government, and legislature implies the House to make law. So, if the ministers and the House to make law, if they try to make any law which violate the Constitution, if they try to make any law which is against the Constitution, the Supreme Court will defend the constitutions. The fifth power and functions of the Supreme Court is guardian of fundamental rights, which means protector of fundamental rights or defender of fundamental rights. The Supreme Court of USA has also acted as the guardian of the rights and liberties of the US citizens and knocked down all the laws and actions which led to the denial or abridgment of the civil rights and liberties. Knock down means kill, scrap, and strike down and cancel all the laws which break the rights and liberties of the US citizen. Abridgment means breaking of the civil rights and liberties. Some of the civil rights and liberties of the US citizens are the right to life, right to property, right to religions, right to education, right to freedom of speech and expression, etc. The Supreme Court can protect the fundamental rights and liberties of the American citizens through the issue of various types of writs like habeas corpus, mandamus, quo warranto, prohibitions, and certiorari. Writ means the written order, the order issued by the Supreme Court. The US citizens can approach to the court, can go to the Supreme Court and file a report, send a report to the Supreme Court if someone break their fundamental rights. And the Supreme Court will issue these writs and send it to those persons who break the rights of others, and he will be judged by the Supreme Court. He will be punished by the Supreme Court. Last but not the least, the power and functions of the Supreme Court is development of the Constitution. The US Supreme Court has done much towards the growth of the Constitution. It has enabled the US Constitution to suit or adjust itself with the changing circumstances of the dynamic world. The Supreme Court has interpreted the constitutions to meet the exigencies of time. Exigencies means the demand or requirements of the situation. This means that if the society changes, if the situation, the condition of the world changes, the condition of the state, the society changes, Constitution also needs to be changes in order to adjust it with the changing of the society. The American Constitution is like a skeleton document comprising only 7 articles and about 7,000 words. By putting a liberal interpretation, the Supreme Court has facilitated the growth of the Constitution. In the words of Justice Hawks, Americans are under a constitution, but the Constitution is what the judges say it is. Skeleton document means that a document or a books which do not have more articles, which do not have more words, which have less words and less numbers of articles. American Constitution is called as a skeleton because it does not have more substance. Liberal interpretation means the freedom of the judges to explain the Constitution, to clarify the Constitution, to change the Constitution, and to define the meaning of the Constitution. From the above discussion, it is clear that the Supreme Court is an institution of great importance in the American federal system. According to Feiner, it is the cement which has fixed, formed the whole federal structure. American federal system means a kind of government which has the state government and the central government. And in America, there are 50 states. These 50 states are called as the Union of States, and the powers is divided and distributed between the central government, which is called as the federal government in US, and between the state government. According to Feiner, the US Supreme Court is like a cement. Cement means it's like a substance which makes the relationships of the state government and the central government very strong and stable. It has proved to be a balanced wheel between the legislature and the executive. The Supreme Court maintains the balance of power. It makes the power of the legislature and the executive to be equal. It has acted as the guardian of the Constitution and fundamental rights of the people, and also enabled the Constitution to mold itself, to shape itself, and to develop itself according to the changing needs of the situations. Despite the fact that its decisions have sometimes been criticized, raising finger at its impartiality, Lasky remarks about the apex court. Apex court means the highest court, the top court, as one of the most successful institutions, not surpassed by any other institution in its influence in the life of the United States, may not be treated as exaggeration. Lasky said that the Supreme Court, which is called as the apex court, is the most successful court or the most successful institutions which cannot be compared by any other institutions. Therefore, we cannot look down on it, or we should not disregard its importance. So now we have come to the end of this topic. So if you have any doubts, or if you have anything which you don't understand, please feel free and frank to share it in the comment section. I am ready to clarify your doubt. Thanks for watching my videos. Till then, bye bye. See you in the next video.